Good evening, ladies and gentlemen, and welcome again to the Polsky series. If you are back, we're glad to see you again, and if you're here for the first time, thank you for joining us. Tonight's program is titled, Who Decides, You or the Judge? Your Finances, Your Family, and Your Health. I'm Emily FOWLER, Polsky Series Director. And before we get started, I'd like to request that you turn off any phones, Blackberries, or other electronic devices so we don't disturb those around us during the program. Thank you. I'd like to take a moment to recognize Dr. Terry Calloway and Marlene Calloway. Are they in the room tonight? Dr. Calloway is the president of Johnson County Community College. And I'd also like to take a moment to recognize Norman Polsky, who's sitting in the center of the theater tonight. Norman brought several of his family members with him this evening, and I want to remind you all that the Polsky Practical Personal Enrichment Series is underwritten for the 4th year in 2008 by the Norman and Elaine Polsky Family Supporting Foundation within the Greater Kansas City Community Foundation in partnership with Johnson County Community College. The college is lucky to have this beautiful Polsky theater in which to hold these seminars, and this space hosts a variety of other programs each year as well. So thanks to Norm and Elaine Polsky, for which this theater and the seminar series are named for their generosity to the college and to organizations across Kansas City and the nation. I'd also like to take a quick minute to acknowledge our wonderful television and Carlson Center crews, as well as the horticulture program here at the college for the trees on stage tonight. They have to cart these over here. That's not an easy thing to do, so thank you. And now, ladies and gentlemen, let me tell you, first of all, we have a table in the lobby with a lot of additional information to what I'll take you through in the packet in just a moment. The Community Foundation of Johnson County and the Greater Kansas City Community Foundation, represented by Corey Ziegler on our panel this evening, has brought several pamphlets and flyers that you'll want to take a look at before you leave here tonight that are related to some of the topics we'll be talking about. And in addition to that, we do have information also from Kansas City Hospice, including a durable power of attorney for healthcare decisions form, which you may want to take with you tonight if you or a loved one is in need of that information. It will be available at the table in the lobby. So now let's look through our packet, which is a famous thing at this point in the Polsky series. On the left side, first in blue, is a biography of Norman Elaine Polsky, and this is an updated biography as the Polskys were recently honored at the Shakespeare Festival Gala held on February 16th. On the back of the blue page is a list of the Polskys' 40-plus endowments that support organizations all over the United States and in Israel. The second page, in pink, is Norman's investment article dated March 10th of 2008, and on the back is a list of his Big 8 mutual funds. The third sheet in yellow is Norman's 10 Commandments for a Better Life, so you should read those closely. And on the back of the yellow form is Norman's My Legacy to You, an overview of 5 points from Jim Stour's book, Yes, You Can Achieve Financial Independence, and 11 points Norm feels are important when investing in mutual funds. Finally, behind those in color is a flyer on the next Polsky seminar to be held Wednesday, April 30th, where a panel of experts will tell you how being a volunteer or grantor can benefit you. And lest you think I forgot, also on the left side is the green survey card. Those of you that have been here before are very much familiar with this card. We would like your feedback about tonight's program, so before you leave tonight, fill out this card and hand it to an usher. Before you walk out that door, we would love to have your opinion of what we did well, what we can improve. And on the other side, you can add yourself to the mailing list. If you are not currently receiving our mailings, you can share your email address with us or give us future topic suggestions. So we hope you will give that to us before you leave tonight. We're looking for 100% return on those. Thank you. You'll also find a blue question and answer card. And if you have a question for one of our presenters during the program, please fill this out. The ushers and I will be around during the program, and we will pick these up at any time. So if you wave me down, I'll come by and get your question card. And Joe Sobchik, who's the Director of Institutional Advancement and Government Affairs, will moderate the Q&A, and we'll do that for about the last 30 minutes of our program. So please hand these in. Now, on the right-hand side of your packet is a sheet containing biographical information on each of this evening's presenters, and that is followed by a stapled piece, a true-false test of your estate planning and charitable giving IQ, and we promise that by the time you leave here tonight, you'll know all the answers to this test. So don't read ahead. Our featured presenters are going to take you through this information right now, so without further ado, I will turn the program over to Ed Marquette and Corey Ziegler. Welcome.
Thank you very much. Emily, can you hear me all right? No. Okay. Can you hear me now? All right. 1, 2, 3, 4. Is that loud enough now? All right. All right, very good. Wow. That's plenty loud, isn't it? All right. All right. There, I think we're okay now. All right, ladies and gentlemen, thank you very much for coming out on this rather soggy night outdoors. I know coming out here we were stranded a bit on the highway because of the rain. I think my being scheduled out here to speak has something to do with precipitation. Last time I was scheduled here, it was snowed out. So at least it's just wet and not icy this time. So anyway, it's really, really fun to be here with you all tonight and talk about a subject that is, well, death and taxes. Let's face it, not particularly fun, but just because it's a sort of solemn subject doesn't mean that we have to be entirely solemn here tonight. We can have a little fun as we go along. And what we're going to do is basically walk you through the test, and the answer key is there. So, but if you read ahead, that's cheating, and that's not permitted here. So, what we'll do is we'll go through the questions, and then we will go through we'll talk about the answers, and these will be kind of jumping off points, if you will, for us to talk about some of the important issues that relate to determining for yourself and your family who decides. You have the fate of your finances, your family, your friends in your own hands if you choose to do something about it. If you choose not to do something about it, then the government, through the judge or the IRS or whomever, they will decide for you. So the whole point of this tonight is to give you enough information so you can make good decisions for yourself and your family and your finances rather than have someone else do that for you. So without a lot of further falterall and going on, let's go ahead and ask and talk about the very first question. People, I think, if they know anything about probate and estate planning, think of probate as a really bad thing, and they think of taxes as a really bad thing. So the first question, avoiding probate and avoiding taxes are the same thing. True or false? All right, that's a good, very, very good. All right. It is, in fact, false, okay? Probate and taxes are totally separate situations. The mere fact that you avoid taxes will not have any impact on avoiding probate. The avoidance of probate at the same time will not avoid taxes. All right, so you all are doing pretty well so far. Let's go on to question number 2, okay? And question number 2 is, if you have a will, you don't have to worry about probate. False, okay. Either very, very smart or you're reading ahead. One of the two. All right. Yes, false is the correct answer. In fact, a will actually is an instrument of probate. So you do not make out a will for the purpose of avoiding probate, okay? A will serves a number of other laudatory purposes But one of those purposes is not to avoid probate. Well, let's talk about what is this thing called probate that people on the radio keep telling you ought to avoid because it's really a bad thing, okay? Probate is really a general term for what happens upon one's death. A will be admitted into probate court, and that is simply for the purpose of determining that it is valid, that it is genuine, that it isn't some sort of a bogus document that someone came up with, and that it is enforceable. Then the second thing that happens is that the appointment of the executor or personal representative, to use the more modern term, that will be confirmed. Then what happens is the actions of the personal representative or the executor, who sort of steps in as your fiduciary after your death, then distributes the assets of your estates in accordance with the terms that are set forth in the will. So that, in essence, is really what probate is all about. It can be a fairly simple process. It can, however, be a fairly complicated process. And so if a lot of your liquid assets, your bank accounts and things that are needed on a daily kinds of keeping life operational, if those things have to go through probate, there is the possibility that there would be some delay there, and there's also the possibility of expense. So if you can avoid probate, and we'll talk to you about how to do that, that is generally speaking a good idea. The other thing in terms of the cost of probate arises where there may be assets in different states. Let's say you live in Kansas. Let's say you have a lake home in the Lake of the Ozarks. One's in Missouri and one's in Kansas. It may very well be that if all of your assets go through probate, that you may have to have ancillary administration, which means that you have to go through probate not in one state, but in two. Not before one judge, but before two. And that can be very expensive, not to mention time-consuming. So it's very important, whenever possible, to avoid probate. However, as I said, there are some good things about a will. One of those things that's very important to have about a will is it decides, it's one of the instruments that decides where your assets go. As I said a moment ago, the executor or the personal representative carries out the instructions in your will. So what happens if you die without a will? All right? Well, the judge decides. The law decides who gets what. And that may relate not only to your assets, but maybe also relates to, let's say, your minor children. Let's say, for example, that you are a single parent. Your ex is a little crazy, maybe a lot crazy, for whatever reason. And you may have a relationship with someone else who's really nice, but, you know, not necessarily ready to make that commitment. That's why they're still in a relationship. It's not your husband or wife at this point, all right? So you're in that situation, and then something, your parents, your ex's parents are really not in health condition to watch your small children, take care of them, but you have a good friend, Sue or Tom or whomever, and they would be just absolutely excellent. Well, if you do nothing, then the law is going to take certain presumptions, namely that the members of your family are the best persons. Now, ultimately, the judge is going to decide. You can't override what the judge is going to do because the judge has ultimate responsibility for what's in the best interest of your children. However, your own wishes won't be heard if you don't, in an instrument such as your will, if you don't indicate what your preference is with respect to the custody of your children. So that's another very good reason. Even if you don't have a lot of money, if you have children and you have concerns over what may happen to them, who may be their caregivers, then a will is another excellent document to have. Okay.
Ed, I might add one thing there. This weekend in the Kansas City Star, there was actually a great article in, I believe it was in the MoneyWise section on Sunday, and it was encouraging people to think about their estate plans and get their wills done. And there was an example of a gentleman who lived with his girlfriend for 20 years, you know, the long-term relationship, but he didn't have a will, and she's not his relative under the state law where he lived, and really wouldn't be here either. And so now she's fighting with his elderly mother over assets and all sorts of things, and you know, obviously running through court proceedings and attorney's fees that will ultimately eat away at this estate that could have gone to her if he would have prepared ahead of time. So something to keep in mind, that it's good to at least have something done, even if it's just a will to get things started.
All right. Right out of the newspaper. There you go. What we're talking about is as current as today's news. All right, next. The question number 3, let's see. If possible, always add the name of a joint owner to assets. All right. False? I'll tell you what, that one's a little bit tricky because having assets in joint names is often touted as a very good thing. It is, in fact, a means of avoiding probate. So that's a good, and laudable goal. But I'll let you in on a secret where lawyers are concerned. Okay, whenever you see that word "always," okay,
Don't.
It's going to be false. One of my law professors, when I was in law school, one of my law professors said, you know, here's how you can tell all the, it was his tax, my advanced tax class, and he used to say on days when he was sober, he used to say things like, you know, if you read, he was a nice guy, but did have a little bit of a problem. Whenever you read in the opinion, on appeal, usually it went to the Court of Appeals or maybe even all the way to the Supreme Court. Whenever you see this line that says something like, the witness testified that his accountant told him. Now, immediately what follows is going to be wrong. So it doesn't really matter. So immediately what follows is going to be wrong. Now, that's just because he was kind of prejudiced. But anyway, so joint ownership is a good thing, but not always. So in the proper situation, it is a good thing, all right, because it does avoid probate. But here are a couple of the reasons why just sort of excessive use of joint ownership is a bad thing. It's lumpy. That's the first thing. It kind of applies to the asset rather than in a smooth way where you could lump all the assets together and then divide by the proper percentages. You're instead trying to divide up these lumps. There was a woman who had some suspicions about these fancy new things called trust, and she was taking care of her entire estate plan with her CDs, and by titling her CDs in the names of her nieces and nephews. She didn't have any children of her own, so that was her procedure. And of course, as she cashed them in, she would have to go in and she'd retitle them all. And she was always kind of balancing this one against that. And I kept saying, no, this is finally, after years, literally, I finally talked her into doing a trust. But so it was just lumpy. It was awkward in a kind of a poor way of deciding who gets what, simply by jointly titling those CDs. Well, that's one problem. That's maybe not a major problem, but it is nevertheless a problem. Another problem is when you put property in joint names, that means that those assets may be reached not just on your death, okay, when you kind of think they ought to be reached, but during your lifetime too. So it could be, so if you have your CD in your name and in cousin Theodore's name, both, and cousin Theodore doesn't turn out to be the nice young nephew or cousin that you thought, and decides he's going to check out and go to Bahamas, you know, with your money, boom, your assets are gone. So it may not be a really good idea to put assets in joint names just in a straight-up fashion like that. That's bad enough. The other thing is, let's assume that our cousin Theodore here maybe isn't such a scoundrel that he would take off with the assets, but he does have a gambling problem. And the problem is that his creditors now discover that, oh, he is a joint owner of this CD that is in your bank wherever, and guess what? your asset that you were sort of counting on in case you needed it, but if you didn't, then it was going to go to cousin Theodore. Instead, it goes to cousin Theodore's creditors, and that's a real negative situation. So those are things that are really things that you ought to avoid with joint ownership. Now, there are ways that you can achieve these objectives that are much better than straight-up joint. There are some actual joint tenancy kinds of transactions that avoid some of these problems. There are ways to title some assets, securities, for example, some real estate, under so-called TOD or POD. All right, TOD, transfer on death. POD, pay on death. Pay usually more for accounts. Transfer more for things like real estate. So if you do have assets that you do want to, notwithstanding what we're going to tell you later on, put in joint tenancies, the preferable way to do it is with the TOD or the POD titling of those assets. All right? Well, let's come up to the next question. Let's see. All right, the next question. I'm scrolling down to it here. All right. There's a couple of notes that I had here on that I thought we maybe ought to mention. Other ways of, before I really get to the next question, which is what I was looking at, is life insurance, for example. Life insurance is another way to avoid probate by the beneficiary designation. The beneficiary designation on the life insurance policy or on your 401k or your IRA, those will likewise avoid probate. And those beneficiary designations are perfectly appropriate. Now, that plus all of the other joint tenancies, remember, override your will. So if you have titled assets or have filled out your beneficiary designations a particular way, and then you change your mind, you say, oh, I'll just fix that in the will, and I'll say, and notwithstanding what I provided for in terms of the accounts and the tenancies, I really want it to go this other way in the will. Well, too bad, because the will, as I said, only operates on those things that go into the probate estate. And we're avoiding probate here with joint tenancy. So the will has no effect on what happens to your life insurance policy or what happens to your, if you've made a beneficiary designation, or what happens to those jointly titled assets. So that's kind of a footnote I wanted to make sure that you understood. All right, now, down to the next question. I need a trust because I want to simplify division of my assets upon my death. Second one, I want to avoid probate, want to minimize estate taxes, and want to make it easy for my family to manage my assets if I become incapacitated. That's really not one question, but that's actually 4 questions. And you might anticipate that the answer to those questions are true, 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 true. And I'll even throw in another true. One of the most important things that you can do for your estate plan is to have an inter vivos revocable trust. Now, what does that mean? Inter vivos simply means, it's kind of Latin for during my lifetime. And revocable simply means that you can change your mind. You don't have to be wedded to it. You can change your mind 1 or 1,000 times before your death. What will happen with a trust like this is pretty simple. You would create a trust agreement where you wear one hat as the grantor, and then you wear another hat as the trustee of the trust. And so you then transfer various assets into that trust, naming yourself as the trustee. Then, thenceforth, with respect to those assets, you simply act as the trustee. So when you're signing a transfer document, you sign as Ed Marquette, trustee of the trust dated March 26, 2008, okay? Well, it may be entitled the John and Susie Family Trust. You know, the name is not all that important, but it is a trust that operates to hold the title to the assets. Now, because it holds the title to your assets, that means that it won't pass through probate. So one of those terrific objectives is already achieved. The second thing that it achieves is a good thing, is it gets rid of that lumpiness that I talked about a minute ago when you're using jointly titled assets. And the same thing is true like with life insurance. So you can make your inter vivos trust the beneficiary of your life insurance. And that way you can decide, you got 6 kids and 4 cousins, and you can divide them all, everything up by percentages. All of the assets get dumped into one pot and maybe valued, maybe sold, and then the proceeds are then distributed out of that in the way that you want. And so that is a perfectly beautiful way to make a very easy distribution. Another really wonderful benefit of a trust is that it's great for minor children. You can set up a trust, and this doesn't have to be in an inter vivos trust. You can have a trust spring out of your will for your minor children, so that the funds that are set aside for them are not accessible by them, or more importantly, by their creditors. So the funds can be set aside in this trust to pay not for their fancy car when they get to be age 16, or more likely when they reach majority age 18 or 21, depending on what state you're in. Still a few 21 states. You can set it aside and say, no, that money is going to be used after I'm gone for my children's education and for their health and for things related to that, not for frivolous, silly, stupid things, okay? You might want to phrase it a little differently than that, but anyway, that's the idea. And then after that, you may want to even set the time when they get the money at a much later date than age 21. You may want them to become a little bit more mature. So that's another good reason. And then the last of the 4 reasons really gets to this subject matter that we really haven't talked about yet. We've been talking about what happens when you die, but there's this other thing called incapacity. And that is when we're all living a lot longer these days. And this incapacity becomes actually more of an issue than it used to be. As we age more, then we get into situations where our minds aren't working quite the way they used to, and we may not be in a position to make decisions for ourselves. So having a trust where you have a successor trustee or another person who is a co-trustee acting with you can step right in and start managing these assets for your benefit at such time as you're not really in a position, maybe mentally, maybe physically, to get around and get to the bank and do some of those things. Now, there are also powers of attorney that we'll also talk about a little bit later, but certainly having the assets in a trust makes it very, very, very easy to have your assets managed in the event that you become incapacitated physically or otherwise. Okay? Let's look at the next question. Make sure I've covered everything here. Hold on. Okay, that's the minor children. We've covered all of that. All right. The other, another thing that is, I think, kind of mentioned in the materials, but kind of a little bit obliquely, and that is avoidance of estate tax. Corey's going to be talking about the estate taxes here in a moment, but by using a trust, you can take advantage of some of the advantages of the tax deductions. For example, you have an unlimited marital deduction. And so some people think, well, okay, why do I have to worry about estate taxes? Because everything that goes to my spouse is going to be tax exempt. Well, that doesn't what happens upon your spouse's death. So there are techniques that you can use by using trusts that you can avoid both those sets of estate taxes if you do it correctly. And that can be a little bit more complicated than your typical trust. But you can set up matters in using trust so that you avoid the second tax on the second of the spouses to die. Okay? There's one other sub-point on the children. If you've, I had a situation, this is in fact a true story, where the person was untimely killed, and then funds were made available, and this person elected to take the funds in a lump sum, which this person seemed to think that she'd be able to manage the assets in a much more efficient way than just having the funds paid out in installments. It was really from insurance. Well, what she went through then was this process of a conservatorship, which is if you don't have a trust set up for your children. A conservatorship, and I really wanted to make sure I covered this point, is a very, very expensive proposition. Because there are numbers of distributions, a number of transactions that have to be approved by the court. And while you may think that you're really great in running your checkbook and managing your own personal finances, having someone looking over your shoulder is really, when it comes to your own personal finances, can be a very uncomfortable and kind of disconcerting thing. So that is certainly something that you will want to avoid. And it's therefore a very, very good idea not to saddle your spouse with something like that. So setting up a trust to cover situations like that can be very, very useful and avoid lots of headaches and expense. All right, I need a trust because I want to avoid taxes. Well, I'm going to answer that one really quickly. And that is no. That one is false. You cannot avoid taxes completely. That is to say, if your estate is large enough. Taxes may not impact you if your estate is small enough, but just having a trust is not the answer. Well, I'm going to shut up and let Corey have a shot at it for a while, all right?
I know this is everybody's favorite topic, taxes, especially this time of year. I think we've got a little less than 3 weeks to go before April 15th. So this might be a question that you've asked yourself before. A trust will only complicate my income taxes. And the answer to that one, as you might see there, is false. A lot of folks that when I was in practice would ask, if I'm going to set up this revocable trust, I don't want to deal with it because it's just going to be additional paperwork. There's going to be more tax returns we have to file. And the good news is that you do not have to file a separate tax return for a revocable trust. As the grantor of the trust, the person creating the trust, and the trustee, typically that person creating it is also acting as trustee. There is no need to file any separate tax returns. It all gets lumped into your own income tax return, your individual income tax return. You might have situations where you have what's called an irrevocable trust. Those are other special types of trusts that sometimes are used for different tax planning or planning for the family in the future. And those might have separate income tax returns depending on how they're created. But the good news is the revocable trusts, which are kind of a substitute for a will, those do not require separate tax returns. So you can check that one off your list. You don't have to worry about that. The estate tax is another issue, and you may have heard over the last several years of legislation that's affecting the estate tax. And I know when I was in private practice and the legislation came down, we're all looking at the Internal Revenue Code, trying to figure out what's happening and trying to plan ahead, because the estate tax exemption has continued to rise over the years. And then we're going to have a nice hiatus from the estate tax in 2010. But this is all dependent on who is president and who's in Congress, and gosh, who knows? I think we've all had different ideas on what might happen. But let's start with the federal estate tax. And that exemption, is it currently $2 million? Yes, it is. It is. And, frankly, that's going to catch a lot of people. When we say an estate tax exemption, that means that you can have $2 million worth of assets at your death and pass those on to family members, friends, whoever, and you won't be subject to federal estate tax. The $2 million, when you're looking to try to calculate what that is, you actually look at everything you got. That includes all assets that are in your own name, any assets that might be held jointly with others, and then there's sort of a reduction there. There is life insurance proceeds, the actual death benefit of a life insurance policy on your life that you own. That will be included in your estate. Your retirement plans, real estate, cash, stock, all that kind of stuff is all rolled into that number. And so really you can get to that $2 million pretty quickly. I know, a lot of us feel a little bit more wealthy dead than alive, because there's a lot more that's coming once you die with life insurance and things like that. So it's something that is a concern, and people should really take an inventory of what they have and look to see where they fall. But the good news is the estate tax exemption is rising. It's $2 million this year. Next year, starting on January 1st, which, gosh, when this all started, seemed like eons away, is going to be $3.5 million per person. So between spouses, currently spouses together have a $4 million amount that they can essentially work with. Now, Ed mentioned this earlier, you want to be careful as you're looking at your assets and deciding if estate tax planning is something you need to do. And this is something that your estate planning attorney can easily help you with. But a lot of times if you've got a surviving spouse and things are going well with that spouse, a lot of times people say, okay, let's do a honey, I love you will. I love you, I'm going to give you everything. And so you do. Well, you don't have to pay estate tax on that first death, because anything that you give to your spouse qualifies for the unlimited marital deduction, so you don't have to worry about how much you're giving them. You could give them $75 million, and there's no estate tax at your death. The problem is the spouse then has $75 million, and if they die with those assets in their estate, there's going to be a significant estate tax. And so something that Ed mentioned earlier is the possibility of doing some planning where you might not give all of your assets directly to your spouse. You might leave some in a trust for the benefit of the spouse that has special provisions that gives the spouse very flexible access to the trust, so they're not sitting out there wondering, gosh, could I have money to pay the bills? But it does allow for some tax planning, in the sense that the money that is put into that trust bypasses that surviving spouse's estate. It's not something that's included in their estate when they pass away. So when I mentioned that you've got $4 million really to work with as spouses, the first spouse has $2 million and the second spouse has their $2 million. And the first spouse's $2 million that gets passed to the surviving spouse through this trust arrangement then goes on possibly to children or grandchildren or whoever without being subject to estate tax. And that's a really great way to do some planning. As these exemptions are increasing, more and more people are falling within the exemptions, which is nice, so you don't have to worry about it. But just because you might not have estate tax due doesn't mean you shouldn't be thinking about estate planning. And for all the reasons that Ed has talked about already with guardianships for minor children or incapacity issues, you really do want to make sure that you're doing it. And also just to make sure that your assets go to the people you want them to go to, and not letting the law decide or the judge decide. When we get into another type of tax, it's funny, I went to law school, I had no idea. There were so many different types of taxes to deal with. But in the estate planning field, there's kind of the big three. You've got, well, actually four. Income tax, estate tax, and then gift tax is another one, and I'll get to that in just a second. And then there's also something called the generation skipping tax. And that's beyond the scope of this, but that deals with assets that you might pass to your grandchildren. When you skip over your living children, you can give to grandchildren. So there are issues around that as well, which luckily attorneys in this field are very knowledgeable about that, and you can always go to them for those types of questions. But there are a lot of tax issues that come up in estate planning, and that's why it's always good to get some good advice when you're looking at these issues. But the federal gift tax exemption currently is $1 million, and it used to be that that was tied to the estate tax, and they were oh, there's a special word for it, and I'm just forgetting it. They were tied together, so you didn't have to worry about keeping track of this. But now the gift tax exemption is just $1 million. So the purpose of that was the IRS didn't want you to say, well, okay, if I can't pass it on at my death, you know, over a certain amount, let's give it away during our lifetime. Well, they wanted to make sure they were catching people that were doing that and taxing that situation. So now you've got $1 million during your lifetime that you can give away to other individuals. Charitable gifts to charities aren't included in that because you get a charitable gift tax deduction. Gifts that you give to your spouse, again, are not included because that's a marital gift tax deduction. But if you're giving money to friends or other family members, this comes into play. Okay, let's talk quickly about the state estate tax. The federal government likes to tax, but so do the states. For those of you living on the Missouri side, it's pretty simple. The estate tax in Missouri was tied and is tied to the federal estate tax, and actually there is no more state. Well, Ed, you can correct me if I'm wrong on the timing of this, because it's been a while since I've been doing this. The Missouri estate tax, there used to be a credit that you could get for taxes paid to Missouri on the federal return, and now I believe that's been phased out at this point for Missouri. So there isn't a separate tax there. But on the Kansas side, they have what's, the technical term is decoupled. They have decided, hey, wait a minute, we're not going to do what the feds say. We would really like to have our own revenue from the estate tax in Kansas. So a few years ago, they decided, well, let's make things complicated, and let's tie our estate tax to the version of the Internal Revenue Code that was around in 1997. So they did. And those of us practicing got to flip to the pages in the Internal Revenue Code that have the itty-bitty tiny print when they go back and they show you current, older versions of a particular section, and you stare at that and figure out exactly what Kansas is doing. But basically, they have a lower estate tax exemption. So there's a chance that you could have federal estate tax that is not due because you're within the $2 million exemption, but you're over the $1 million exemption in Kansas. So you could owe Kansas estate tax but not federal estate tax. It gets kind of complicated, but it's just something to be aware of, and your estate planning attorney could certainly help you figure that out. And there's ways to draft your documents that can minimize the taxes, especially that you pay at the first death. Typically, if you have an estate plan, you're not paying any estate taxes, whether Kansas or federal estate taxes, at the first death. It's only when the surviving spouse dies that that might come into play in a typical scenario. But as I saw, there's really not a typical scenario. Everyone's got a different plan, that's for sure. Let's move on to life insurance and retirement plans. And those are kind of special types of assets, and as I mentioned earlier, they can actually really increase your taxable estate for estate tax purposes very quickly. You might think, oh gosh, I don't have a lot of money sitting around, but you really do when you look at those types of assets and you look at the death benefit on life insurance. The question here is life insurance and retirement plan benefits passing directly to a charity following death avoid both income tax and estate tax. Do we know what this is? It's true. Let's start with life insurance. Life insurance proceeds, if let's just say you're an individual and maybe your parent has died and they've left some life insurance to you and you receive that as a beneficiary. That will not be subject to income tax to you, the beneficiary. When you receive the cash distribution from the life insurance company, you do not have to worry about paying income taxes. But the life insurance is included in your parents' estate. So when you're looking at that figure to determine if they owe estate tax at their death, the death benefit proceeds, the full value of the proceeds that the beneficiary receives, is what is included in that deceased person's estate. Now, if you transfer a life insurance policy, let's say you've provided for your kids and grandkids and you want to do something for charity. A life insurance policy is kind of a nice way to look at things. You can actually transfer a life insurance policy to a charity and to make the charity the beneficiary of the policy. That does two things. One is it gets the life insurance policy out of your estate for estate tax purposes, so that $150,000 that's going to be paid at your death will not be added into the figure for your estate tax purposes. But then as you pay premiums on the life insurance policy, if you still owe premiums, you are making another charitable gift to the charity because you're giving the money to them to allow them to pay the premiums. And that's an additional charitable gift for you. It qualifies for an income tax charitable deduction. And then when you die, the proceeds are paid to the charity, and that's not something that is affecting your estate tax situation. So it's a nice way to provide for charity at your death and also get some money out of your estate. The other type of asset, the retirement plans, the 401ks, the IRAs, that's kind of even a bigger whammy when you look at that for estate tax purposes and also income tax purposes for your beneficiaries. If you are, which a lot of us have done, and I know I have done at this point, leaving your IRA to spouse or to children, when they receive distributions from your IRA, that's subject to income tax for them. And unless it's a Roth IRA, that's a different scenario. But a traditional IRA or 401k plan, they will have to pay income tax as they receive those payments because that was tax-deferred money that you put into the plan. Well, when they receive those, they've got the income tax hit, and then they also may have had an estate tax liability, or your estate may have had an estate tax liability when you died because the IRA or the 401k was included in your estate. So there's a really good chance that a much smaller percentage of those assets will actually get into the hands of your beneficiaries because of the estate tax possibility and also the income tax hit when they get distributions. So sometimes when people want to provide for charity, we really encourage them to look at those assets first and maybe use those to provide for charity and maybe offset that asset with maybe a life insurance policy or something to pay to their children, which again does not cause income tax problems for the children. And the reason for that is when an IRA or 401k gets paid to a charity, because the charity is exempt from income taxes, they don't have to pay the income tax liability when the assets are distributed. And then it's also subject to an estate tax charitable deduction for the deceased person because it's money going to charity. So really, that's a win-win situation for everybody because that's money the charity then has to use for their programs, but it's also not going to be eaten up by the taxes that it otherwise would be going to an individual. So there are a lot of issues, a lot of scenarios you kind of have to look at depending on the types of assets that you have, and that's why it's really important to sort of sit down and take an inventory of what you have and look to see there what makes sense. Now, obviously, if you're not charitably inclined, that may not make sense for you. It's interesting, when I was practicing, I had a lot of clients, and especially in my generation, I got to provide for the kids and, make sure that they're taken care of, obviously, before we do anything else. And then we'd have kind of the discussion, well, what if the kids are gone? Well, if they're old enough, they've had grandkids, we'll make sure to provide for the grandkids. So it was kind of, we got into this discussion typically that if everybody's gone, maybe we've all died in a common accident or something terrible, then we'll give it to charity. So that is a discussion I a lot of times would have with clients and saying, if charity is something that you're doing now during your lifetime, you might want to consider carving out a piece of your estate plan for charity at your death. Because if it's something that's important to you now, and it can make some estate tax and income tax benefits down the road, it's not a bad idea to consider it in your estate plan. But again, that has to be a personal decision, and I saw that many times where it just wasn't something that the person wanted to do, and that's perfectly fine. They just need to then plan for their beneficiaries to deal with any tax issues that might come up. I kind of have answered the next one a little bit, but number 12 here, you cannot name a trust or a charity as the beneficiary of an IRA or 401k. So you know the answer to the charity part. What about a trust? No? That's right. That's right. You can name a trust as a beneficiary. There's some complicated rules around that. And, you know, a lot of times when people are looking at IRAs and 401ks and making those payable to beneficiaries, they also look at sort of stretching those payments out to the beneficiaries based on their life expectancies, because then that means they can defer the income tax for years on end. And if you have a trust involved, sometimes those payouts get accelerated just a little bit depending on the terms of the trust. So you just have to look at that as something that you and your estate planning attorney can work through. But you can name a trust as a beneficiary. And frankly, if you have very small children and that's one of your main assets is a retirement plan, it's not a bad idea to have that money going into trust for their benefit and then distributing out according to the terms of the trust. So there will be tax issues there, but it's just something that you kind of work through as you deal with these different situations. Let's see, I think I covered the main thing. One real quick thing on the involvement of charity in some of these types of estate plans. The life insurance and the retirement planning type assets, as I mentioned earlier, not only for the estate tax and income tax benefits, but also just for the leveraging ability that you have there, is a nice way to consider doing some things for charity because of the fact that they're not having to pay taxes like your individual income beneficiaries might. So it's smart to look at the types of assets that you have and sort of be strategic about which ones go where. Ed, I'll let you take number 13.
All right. Number 13. Number 13 is a fairly straightforward one. The question is, you still need a thing called a durable power of attorney for both financial and health care matters, even if you have a revocable trust. The answer to that is true. Good. Absolutely. Why don't we just talk a little bit about all the pieces of paper that when you do your estate plan that you need to have, all right? First of all, we've been pushing tonight the inter vivos revocable trust. That's probably the single, if you don't remember a darn thing about tonight other than that, that's probably the most important thing to remember is that is your most flexible, most powerful, and most useful estate planning tool. You should also have a will. Often what we recommend is a so-called pour-over will, which basically says, I'm here as a backup in case something misses and doesn't fall into the trust. And if that's the case, then I'm speaking here as the will, I'm going to be basically creating a copy of this trust as a testamentary trust, and everything will go into the trust just as though it had been done right and went into the trust during the testator's lifetime. So those are two documents, okay? Your basic pour-over will and your inter vivos trust. Power of attorney, we almost always do durable powers of attorney anymore, come in two flavors, and we recommend that you have both and that they be separate because there are reasons to do things separately, all right? The durable power of attorney continues in effect even if you become mentally incapacitated for whatever reason. The financial matters one allows your attorney in fact, which is a technical term, to do things that you would ordinarily do if you could for yourself. Some things that your trustee can't do. Your trustee only has power to act over the stuff that's in the trust. Whereas the attorney in fact, under the durable power of attorney, is you. I mean, he or she is your alter ego and can do anything that you could do, that person can also do. File a lawsuit, apply for Social Security benefits, whatever that may be. Okay, so you want to be really careful in terms of to whom you grant that power. It's a very important power, and you should grant that only to someone that you really, really trust. Okay? Then the health care power of attorney, that becomes really important for some practical reasons. you have attached to the materials at the end of the answer key to our true-false questions, you have a thing called a HIPAA designation. What that does is allows the docs and the nurses to communicate your health care information about the medications you're taking, about the nature of your condition, things like that. Because under this law, the Health Insurance Portability Act, which really seems to have very little to do with insurance, but has a lot to do with privacy, okay? And so that P in there really is, has nothing to do with privacy, although the Act seems to be all about privacy. Anyway, so a lot of people think that P stands for privacy. No, it stands for portability, but this law is all about privacy. It drives the people in the healthcare field nuts because they're always paranoid that something is really going to go wrong. They're going to get sued for violating HIPAA, and probably for good reason, because it is a very technical law. And they will not tell, your physician, your nurses won't tell you jack if you don't have this, this HIPAA document. The document that you have attached there will, if signed, allow information to be disclosed to the persons who are named in that document. So that's a freebie. Okay, that's another document to have. Now, I've talked to you about a durable power of attorney for financial matters, and then there's also one for healthcare matters. That's different from the HIPAA document. The HIPAA document is another document. The power of attorney for healthcare matters would allow your person to go pick up the medicine. While the HIPAA document will allow the doc to tell people about it, it won't really allow them to do much more than that. So if you have someone that you want to be able, say, for example, your daughter-in-law is a nurse, you may want to give your daughter-in-law, someone you trust, all right, and like, hopefully, you may want to give that person a power of attorney for healthcare matters. That person can then talk to your doctor, can then pick up medications for you, can even suggest things that otherwise you won't be able to do. So, the documents we've talked about the will, we've talked about the inter vivos trust, we've talked about two different powers of attorney, both of them durable, one for financial and one for healthcare, and we've talked about the HIPAA document, which is what we have attached. All of these are very important, and all of these serve wholly and completely different purposes. That brings us down to question number 14, which is basically, if I go into a hospital and I want life support to be cut off, you know, it's important enough that I tell the doctors and nurses, after all, it is 2008 and we no longer live under these barbaric rules like, you know, the Nancy Cruzan case and things like that, where people by law are required to keep me in a persistent vegetative state. That's the technical term for it. And so the answer to question 14 is false. Yeah, it really is. If you do not want to be kept in a persistent vegetative state, then you need to have a document that we call, my favorite term for it is a healthcare directive. And that basically authorizes, and sometimes you can throw in sort of the living will kinds of provisions that sometimes the hospitals will have forms for you to fill out for your organs to be transferred to someone else. But anyway, the main purpose that we're talking about tonight for the healthcare directive is to allow for the cessation of extraordinary means to keep you alive where real hope for recovery has gone away. So, all right, that's 13 and 14.
Okay.
Lori, back to you.
Which is good. We're just about out of time, and I will finish up on number 15. If you have a gift with a value in excess of, or if you give a gift with a value in excess of $12,000 in any 1 year, the recipient will have to pay income taxes. And the answer to that one is false, correct? The nice thing about the gift tax, if you can say that, is they give you an exemption per person every single year. So aside from the $1 million exemption we talked about earlier that applies for lifetime gifts, you can give away $12,000 currently, and it's adjusted for inflation, so it goes up occasionally. But each of you can give away $12,000 to everybody in this room, and that does not count against your $1 million exemption, and it's not something that you have to worry about paying gift taxes on. Gift tax is something that the donor, the person making the gift, has to pay. The recipient of a gift does not have any taxes that they have to worry about. It's not subject to income tax. It's not something that they have to report anywhere. But the person making the gift sometimes does have the gift tax that they have to worry about. So the nice thing is you can give away $12,000 every single year to everybody in the world, and that gets money out of your estate, which is nice. And you can include me in that gift giving if you like. But you don't have to worry about that counting towards your million, which is really great. And the same holds true for gifts made to charities. Those don't count towards your million as well. Just so that's something to keep in mind is if you're looking at ways to reduce your estate for estate tax purposes. I think we'll actually let Joe come up. He's going to give us some really tough questions, I have a feeling.
Well, Corey, they're very interesting questions, so
good.
I hope you're ready for this. Let's give a big round of applause to Ed and Corey. They're able to somehow make the issues of death, taxes, being physically disabled on life support systems halfway bearable to help us get through the evening tonight. So thank you very much. We've got some incredible questions here, and they're very much true-to-life examples. So we're going to start with the first one. What's the best way to arrange installment payouts of inheritance to a child who has proven unable to handle large sums of money? And that's my children are challenged to handle small sums of money, let alone large sums. So what's the answer to that one?
You want to start?
I'll give that one a shot. Well, we kind of go back and fall back on the tried and true trust. What I would recommend would be to set up a trust, and that trust would have what we call spendthrift provisions. And spendthrift kind of sounds like maybe the situation we're talking about here. The spendthrift provisions basically say that the trustee has the authority to determine what gets paid out. Now, you would typically say for the beneficiary, in this case the child's health, welfare, education, and other things that you might want to specify. Maybe not skydiving lessons. You might exclude some things that you don't really want them to do. But you would put those provisions in a trust, and then the trustee would, after such time as you're no longer able or no longer around to make those decisions, then the trustee would make those decisions. Again, it would have to be someone that you trust, whose judgment that you trust, would make those decisions. The child could not get his or her hands on that money until such time as the trustee releases that money to the child to satisfy those requirements. So, for example, in the example I gave, to pay for college, or if there are medical needs, to pay for that, or for housing needs, to pay for reasonable housing needs, but for no other purpose. That kind of a trust, even if the son or daughter or child has creditors that are standing at the door ready to scrape up every penny, they can't really touch the money that's in that trust, and they can't intercept the money before it is paid out for these other kinds of basic needs that you've specified in the trust. So,
I saw a couple examples of that actually go a little bit further than just the spendthrift provisions, and also the setting out for health and education, those types of provisions. Sometimes I even saw donors or individuals that were creating their estate plans go on to say, well, we'll make a distribution, but only after the child has graduated from college, and putting in some sort of lifestyle type provisions in there as well on encouraging the child to be responsible and taking care of themselves first before they get this money. And there were some situations even where parents didn't want their kids to know that they had this trust out there. And so these days there are some laws that the beneficiaries do have some rights there to know about what's there, but you can get creative on how you provide for your kids if you have those concerns.
Okay, here's the next question. And we really want to thank you for putting so much time and effort into some of these questions. They're very well written, and in some cases they share an awful lot. In this case, my father divorced my mother and has since remarried. How do I approach him to ensure that family money will pass to me and my siblings? As opposed to the new wife and her kids, they have been remarried for more than 10 years. They live at... No, I won't go there.
Well, you just go straight up and you say, Dad, you're not going to give all your money to that hussy and her kids, are you? Just kidding.
I'm sure that's been done.
Well, I mean, that's frankly probably more of something for, the used to be Ann Landers and Dear Abby than it is probably for the lawyers. Yeah, Dr. Phil, there you go. I'm sort of out of touch. But anyway, really I think a situation like that is a time for frank discussions about, honestly, what's fair. Perhaps cutting out the second wife is, first of all, not even really totally possible, because you have to understand what your limits are, because the spouse is going to have the ability to take against the will. I'm also assuming here, which gives the spouse an opportunity to get so much, almost regardless of what is provided for. So what you're talking about here has got to be a situation where it's understood, agreed, and it needs to be done now, hopefully while everyone is still civil and everyone can agree on what is fair and what is reasonable. Because if you do that now and the spouse then says, well, I understand and this is fair and reasonable, then you can get waivers. Sometimes they're hard to enforce, but you can get waivers of those rights to take against the will. So sitting down, agreeing in advance on what is fair and what is reasonable, and then setting out a plan to make that happen and getting in the proper waivers, it seems to me is probably the only reasonable way to go about this. And waiting and just sort of hoping for the best until after Dad is deceased is really a bad idea, because that's just going to likely produce a battle. Mm-hmm. But during lifetime, it won't. The affection that the new wife has for Dad is probably, when you're sitting down in a friendly situation, is likely to produce a much better result. Maybe not the best, but certainly a much better result than after death. Corey?
The only thing I would add is there are ways for the father in this scenario to provide for his new wife, but yet also ensure that there'll be assets going to his children from his first marriage. And those are special types of marital trusts where it'll provide maybe just income out to his surviving spouse, so she's got a support. And in fact, it could also provide for principal payments to her as well. Those are the underlying assets of the trust. The principal payments could also go out to her for certain purposes. But then the remainder at her death, whatever's left in the trust at her death, would then pass to his children from his first marriage. So you can have both worlds, where you provide for the new spouse and also make sure that your children from your first marriage are provided for. So there's ways to compromise, assuming everyone's on the same page.
But the key is, when they're not on the same page,
right,
it can be pretty expensive to challenge that, can it?
Tremendous.
Well, yeah. Yes, and you see a lot of fights over the sentimental stuff more than anything sometimes. The tangible personal property in the house, the stuff that can't, well, this was Mom's, and why is it going to surviving spouse, the new wife. those types of issues come up a lot, and there can be a lot of fighting and attorney's fees spent on fighting that take away from those assets eventually getting to the family.
Okay, we have the father and daughter backstage. Would you come out? A whole new dimension to the Okay, here's another question. I have an adult child who is mentally handicapped but not legally disabled. Can a trust be established that will effectively distribute his inheritance over his later adult years in order to assist in his money management?
Would you repeat that one? I want to make sure I understand.
Sure. This is the case of I have an adult child who is mentally handicapped but not legally disabled. Mm-hmm. Can a trust be established that will effectively distribute his inheritance over his later adult years in order to assist in his money management?
Well, that's really pretty similar to the answer that we gave earlier on the spendthrift trust. Here the need is different, but by establishing a trust and picking a trustworthy trustee who will be loving, compassionate, and concerned about the well-being of this child who's now an adult, then you can achieve those objectives where you have a trustee who is acting in the best interest of the of this child. So again, the answer is the trust.
Mm-hmm. And there's nothing that says that a trust has to terminate. You can go for the lifetime of an individual until their death, and then it can go on for someone else's life. I mean, you can definitely have that where you can take care of someone for their lifetime.
Okay. Oh, Emily, here's one. When will this program be on Channel 17?
This program will air in a couple of weeks on Channel 17, Time Warner and Everest, and Channel 22, Comcast. And we do air Polsky series regularly on Tuesday nights and on Saturday afternoons.
Okay, thank you.
Thanks for the plug.
So we come on right after Dancing with the Stars?
Ed, you mentioned Cousin Theodore going to the Bahamas, gambling away the family's assets. Do these things really happen? And what's the wildest case you've ever had? I don't know if you can share that.
You know, I will tell you the wildest case, although it wasn't, there were, yeah, what can I share? We did have one, which isn't really responsive to that question, but this is actually a true story where the estate planning lawyer in California had redone the trust, and the trust was going to give a very, very substantial sum in the new estate plan to the new beneficiary, which is going to be a charity, and it was a charity that we represented, and so we were very happy to have this great donative intent. And so his estate planning lawyer had prepared all the documents, and the donor in this case was very, very, very ill, and so had the documents all there, ready to sign, bedside, and everyone looked around. No one had a pen. You probably know the rest of the story. They literally, you think this only happens in the sitcoms, but they said, well, we'll go, there's a pen in the next room on the desk, and by the time he comes back, it's, oops, too late. So the moral of that story for all estate planning lawyers, and what I tell all the associates, is always keep a pen with you. The story of having the assets jointly titled is a real potential risk, and it often happens in situations where there's an elderly person, and the elderly person has these fond memories of the younger generation. It's usually not a child or even a grandchild, but a niece or a great niece. And they have remembrances of the cute child, and have sort of lost touch with the adult who's kind of lost touch with reality. And in those situations, some abuse is possible. So, so it's something that may not be your situation, but you may know someone who may be in a situation who's been jointly titling assets in inappropriate, in perhaps highly inappropriate ways, and they are at risk. And those are the situations where I've really seen situations like maybe my little bit fantastic cousin Theodore, but the abuses are indeed possible.
Okay, Corey, this one's for you.
Okay.
The accounts are listed as mother and or son. The mother dies.
Mm-hmm.
The mother's will gives all the assets to the niece.
Mm-hmm.
Who gets the money? The son, the niece, or both?
Well, whatever the account says will go to the son. So an account that's titled, that's the jointly titled situation that we were talking about. The son will get that asset. Whatever the decedent owned in their own name, the mother, whatever she owned in her own name, that will go through the will. So let's say she owns a house or a car or maybe another bank account or something. That goes through the will, which then ends up with the niece. So it really is important how things are titled to know how things are going to pass according to the estate plan.
Agreed.
All right. Here's one for both of you. I'm 44 and am thinking of putting my assets in a revocable trust. Is it too early? Is there an ideal or average age at which most people make these arrangements?
You want to go first on that one?
Well, I was just going to say, when you say, is there an ideal, you wouldn't, I'm sure Ed has the same experience. You used to get so many phone calls, we're flying across the ocean, we need to get our estate plan done, or we're going out of town, or something is happening, and so it triggers it. I would see clients a lot of times that maybe had their first child, and that triggered them to get their estate plan done. But a lot of times it was travel or something like that too. They procrastinated and they're going to fly across the ocean. For some reason the ocean was key, but then they call. So I didn't see really an ideal age necessarily. I mean, I had young clients setting up trusts just simply because of the ease of administration after their death. You don't have to start with the courts. The successor trustee takes over and they continue to manage the assets in the trust and do things according to the terms of the trust without getting the court involved. So I think there is, as soon as you're ready to do estate planning, I don't think you have to be a certain age to consider a trust. I think it's just a matter of, being diligent to get your assets titled correctly so they will go through the trust and not have to go through the will to get to the trust, because that would then make you go through probate. So in my experience, it's been all over the board as far as who does trust, but I think you can start with your very first estate plan. I know I did.
Totally agree, and I've had the exact same experience. Somehow we're about ready to fly over the ocean, and it's time to make that change. So, yeah, whenever you think there's going to be some, or the other one is I'm going to go in for a procedure, okay, and this procedure requires general anesthetic, and I realize that there is maybe a small chance, but there's a chance that I may not come out. So those are the two circumstances. So it's more a matter of life circumstances than it is a matter of age. And understand with the Inter Vivos Trust, really, the assets that are in that trust are really your assets still. You haven't put them out of your reach. You don't change your, you still file, as we said, your same old 1040. You don't have to change any of that. So not a lot of your daily life changes by putting assets in an Inter Vivos Trust.
I'm one of those who did our estate plan before we flew over the ocean.
Were you?
And I'm proud of it, too.
You got it done. That's all that matters.
Okay. Is a Roth IRA completely tax exempt when passed to a beneficiary who receives it upon your death? If not, how does that work? So is a Roth IRA completely tax exempt when a beneficiary receives it upon your death? And if not, how does that work?
The income, I think Corey talked about this a little bit in her presentation. Where you have other, like a regular IRA, for example, that is going to be taxable to the recipient in terms of that recipient would pay taxes on that. The Roth IRA has the special little benefit that the assets in the Roth IRA do pass to the beneficiary free of any income tax, so they can start receiving those funds free of the income tax. I hope that answers the question.
Okay, what is the best way to leave an IRA? Is it okay to leave it to a charity? Yes, you come to the Johnson County Community College Foundation office and you can sign it right over.
You can do it.
Corey, would you want to?
Sure, sure. As I mentioned, besides the tax benefits, IRAs and frankly anything with beneficiary designations are kind of an easy thing to take care of because you fill out a beneficiary form. And naming charities to receive your IRAs really makes a lot of sense. If you're going to do something for charity, go to those assets first before you dip into other assets. There are different reasons for doing different things with charity, and if you know you're going to be supporting the Johnson County Community College Foundation and you want them to have the money and do whatever they need to do with it, then that's a great way to do it. I mean, just pass it right over. They don't have to wait for a court proceeding. There's a really simple process there, and the distribution's made, and then they can use the money as they need it. We have some donors who say, gosh, I want to give to 5 or 6 different charities. One thing that we can be helpful with there is instead of listing all 5 or 6 charities as beneficiaries on the IRA, which sometimes can get a little complicated, let's say one of the charities goes out of business before you die, but you don't change your beneficiary designation, then the IRA companies kind of, there might be provisions that talk about what happens if the beneficiary is gone, but it might not be very clear, or there might be questions raised by the charities. And so one benefit that the Community Foundation can offer is you can make the IRA payable to your fund. It's called a donor advised fund, but a fund that you create at the Community Foundation, that within that fund it then says we want to give it to XYZ charities, and then we would make sure it gets out to those charities for you. And if someone's gone, we make sure to get it to another charity that's like that one for you, depending on if that's what you wanted, or we beef up the percentages for the other charities if that's what you wanted. I mean, we work with you to figure that out. But sometimes if you've got multiple charities that you're wanting to benefit, that's a nice way to do it. One other point on that issue with multiple charities, let's say you have real estate that you want to leave to charity, but you've got like 3 or 4 that you want to go to, and giving 3 or 4 charities the same piece of land gets messy, and then they have to partition it maybe to sell it or something. So another nice benefit the Community Foundation can help you with there is we could receive the real estate for you, liquidate it, turn it into cash, and then give the cash out to the beneficiary charities. Sometimes charities don't want to deal with the real estate anyway, and that's a nice way to handle it. So just a couple of ways that we can be helpful, but we've got materials out there in the lobby, and I would be happy to answer questions about what the Community Foundation does. It's not entirely clear to a lot of people because a lot of people don't know that we're even here, and so just thought I'd throw those couple things in there on ways that we might be able to help you in your charitable giving, but I'd be happy to answer questions afterwards.
Okay, if you set up a revocable trust in Kansas and you also have a rental home in another state, would the trust prepared in the state of Kansas cover that property, or would another trust be needed for the property located in the other state?
Good question.
That is a good question, and it's an excellent reason to have a revocable inter vivos trust, because just as you, as a living person, let's say live in Kansas, but have property titled in your name in Missouri, let's say, your trust can do the same thing. Your trust can be the title holder to the asset. So you would title the real estate in Missouri, using this hypothetical, carrying it all the way through, in the name of the trust, which is a Kansas trust. The trust is an entity. It is an artificial being, is what we like to refer to them as, but it can hold title to real estate in Missouri, in Kansas, and Alaska for that matter, okay? So you do not have to have a separate trust in each state where you have property.
Ed, this is for you. My husband and I each have a revocable living trust. Currently, our home is titled in my trust. Does this preclude us from taking the $500,000 capital gains exclusion if we sell our home?
No.
There you go.
There you go. You said it was for tax purposes. The fact that it is an irrevocable trust, okay, is disregarded. So that it is in fact. Yes, okay. I thought maybe I'd answered too quickly, but I think I'm right. It is disregarded, so it is as if it is owned by you individually. The fact that it's owned by the trust for you really doesn't change that.
Okay, here's something for both of you, and this will be our last question of the evening. Warren Buffett and Bill Gates have said they are against the abolition of the estate tax. Why would they say this, and what's your opinion? This will be on TV, so...
Yeah, that's great. Ed, you can have that first.
I'm guessing a little bit here, but I think to some extent they believe that... I know Bill Gates' father, I think, is actually on record as, in this regard, is that by having the state tax, it promotes charitable giving, so that people will, particularly very wealthy people, will make gifts to charities as a means of avoiding the estate tax. So that if they, the theory is that if the estate tax goes away, then the motive for giving charitable gifts by substantial givers will be reduced. I don't know whether that's true or not, but I believe that's their theory. Corey?
I agree. And that's all I'm going to say. So, I guess my own personal thought is it is tough to see families that have to deal with the estate tax when they're not expecting it. And so it's such a smart idea to really look at this and make sure that you're planning ahead and determining whether or not it's an issue for you at all. And I like the fact that the estate tax exemption is increasing. But, gosh, we're in such a tight budget crunch all over the place. I mean, if there can be some revenue from it that can be helpful, I think that's still a good thing to have. But I do think that the higher estate tax exemption amounts are important. And who knows what we'll see. It's going away in 2010, but it's scheduled to come back in 2011 at $1 million. I think, and Ed, maybe you've heard some on this too, I think they're going to increase that amount at a higher level and go forward from there, but we shall see.
Thank you, Corey. Thank you, Ed. And thanks to all of you for these wonderful questions.
Thank you.
Thanks for coming tonight. Before you leave, I'd like to remind you to fill out your green card, your survey card, and give us suggestions for future programs and your information. Out at the table, you'll find healthcare directive information, hospice information, and community foundation information. So please stop by, grab a cookie and some coffee, and come back next time. Thank you.